promised Lord Justice Hughes that he would go next just to follow up on those comments about the UK. I neglected to find out what Lord Justice Hughes' first name was, unless his parents were clever enough to name him Lord and Justice. But having seen the King's speech, I'm sure his first name is either Lionel or Bertie. But anyway, Lord Justice Hughes.
Anthony's the name, and I am, you're right to say, the English non-lawyer. I used to be. I'm an English appeals judge. I have nothing like the depth of knowledge that Joanna has just displayed in the area that she's been so helpfully discussing. I am, as Judge Fletcher explained, most judges are, explained yesterday, most judges are a generalist. And that's one of the reasons why it's so useful to be at this sort of gathering, trying to understand what's happening in a completely different field. I hope that those of you who are very high-powered scientists, and there are plenty of them about, haven't been in the least put off by lawyers one after the other from this corner of the room explaining some of the limitations of application of what you do. Please don't be. The law is about devising rules for life as it currently is, and about using every tool available. And so lawyers need to know what new information is available. Lawyers are magpies. They gather up snippets of information. They become, for brief periods, not experts, but at least familiar with one day it's banking, the next day it's engineering, and today it's neuroscience. But we need to be able to do it. And we need your help to bring down to our level of understanding the very difficult concepts that you are working with daily. We do, however, need to separate out, as several people have said before, understanding what you do and what you can do from the question of their practical applications within the systems that we have to operate. And the agenda for that, if I may say so, I thought was brilliantly set out yesterday morning by Professor Greeley. And if you have that list of possible applications in mind, if you're a lawyer, you won't go far wrong. So where have we got to? Well, I'm one of those judges who spent quite a lot of time for years trying to explain to jurors that they do have to make from time to time the decision whether somebody intended a particular consequence when they did whatever they did, usually about 6 or 9 months earlier. And because most of us have very limited command of the language and can't be bothered to think up new illustrations, quite often we find ourselves borrowing the rather tired old expression, well, you've got to make your mind up, members of the jury, on all the evidence you have available. You can't, of course, slice off the top of his head and have a look inside to see what he intended. You must deduce it from what he did and the circumstances in which he did it. I came wondering whether you were going to be able to tell me that you could indeed slice off, or without slicing off the top of the head, read the mind inside, and it would save us all an enormous amount of time and effort, and inexactitude, if only we could. Clearly, no, the mind reading is not an available tool, if only because, as you've been at pains to point out, there is no system yet devised, at least, which is capable of revealing when somebody has convinced himself of the accuracy of what he's saying, but he's wrong. and self-deception is stage one of most serious lying. And in any event, the mechanics at the moment simply aren't available to conduct that kind of examination of people's mind, not now in an MRI machine with, I suppose you have to hypothesize, the lawyers gathered round in their gowns addressing the questions through the scientist. It's simply not a practical starter. Nor, sadly, is there going to be available a measurement of past mental states. So neither a measurement of existing truthfulness, currently now speaking about what happened 6 months ago, nor a measurement of mental state at the time of the incident that the court's inquiring into. Again, it's a pity. It would make life a lot easier if it were available, but it isn't. And one day it may or may not be. I have my doubts about that. But what else is there which has got current applications? Well, not a current application, but if the sort of work that Anthony Wagner has been doing on recognition were ever to develop into a system for verifying identification, or for that matter, not verifying identification, it would be enormously helpful. Identification is a vexed topic. It's a topic which is dimly understood. It's an area in which the waters are muddied by the conviction of the honest that they are right, when sadly sometimes they're not. They're good witnesses, they're convincing witnesses, but sometimes they're wrong. If there were ever to be, and it's obviously a mid-term future prospect, but if there were ever to be a system for verification there, it would be hugely helpful. Pain strikes me as an application almost ready to work. We've all known for years that pain is in the mind, and that if the claimant says it hurts, it may hurt even though there isn't any obvious organic reason for it. But what we haven't known is that there might be a way of measuring whether the claimant who says that is truthful or not. And if the central sensitization, which I think is the right expression, if the measurement of the central sensitization provides a means of telling when at least some of those people are likely to be truthful, that will be enormously helpful and might be ready to go, I suspect, comparatively soon. If from that you can develop a means of ameliorating the pain, even better, because of course the cost of pain is absolutely enormous. Risk prediction, I suspect, is the other area where there might be, in the not too distant future, some real some real practical application to be found in the sort of work that you've been describing to us in the last couple of days. We're all increasingly risk averse now. We certainly are in the UK, and I suspect it may not be very different here. We are being led by statute in the UK into more and more preventive orders, sentencing, and indeed pre-conviction orders. The ASBO that somebody mentioned yesterday. Most of us suspect that it's a myth that you can, in fact, that you can really assess risk accurately. But anything that would help would be enormous. Would be a great service. We in the UK are already handing over to the parole board virtually all the really serious decisions that have to be made about imprisonment. They're not made any longer at the sentencing stage. Difficult enough though the sentencing stage is. There's a system for parole at half the nominated sentence. Not necessarily the right place, but that's where it's currently put. and thereafter, in the case of all serious offenders, release depends on convincing the parole board that you're no longer a risk. And all the tools that we can possibly assemble that will inform that decision, we need help with. And it may be that in the not too far distant future, you can find some of that in the imaging of the brain, because at that stage you've got a captive, in every sense, a captive target, and you can control the circumstances in which you can assess him in a way that you certainly can't at the time of the commission of a disputed act. So we may be going somewhere. We hope we are. There may be the odd case in which the neuroimaging might occasionally help with the assessment of conduct. It won't, I'm quite sure, become a measure of responsibility for all the reasons that Professor Morse explained so clearly yesterday. If all the neuroimaging is doing is enabling me to see in the head what I can already see in the behaviour, it's not adding to the assessment of how the man ought to be dealt with. But just occasionally, it might. It's not all that uncommon for people who appear to have done something uncharacteristic to assert that it wasn't malign. It was the result, for example, of a head injury sustained in an assault by somebody else, for which there's no blame of the victim, or a car crash. It would be very useful if one could know through neural imaging whether that might be true or not, or whether it was merely assertion. So just occasionally, I think it will make a difference to the discretionary aspects of sentencing, to what you do with the man. Not in every case, obviously. If people are committed to a series of bad behaviour, it doesn't actually, in the end, matter all that much why. You've simply got to cope with them as they are. But sometimes it does, and sometimes one's judgment of people does vary according to the cause of what they've done. And your work, it seems to me, might be able to help us occasionally with that. So I shall take away lots of half-formed ideas and hope that you will keep us better informed as time goes by and that we can talk to each other again. Thank you very much.